The president has issued executive orders targeting law firms and says one has agreed to his terms. Two others are fighting the orders. The Attorney General and Speaker of the House have mused about ways to minimize or remove judges who have ruled against the administration.
It began quietly, the way some of the most unsettling developments often do. A few whispers inside legal circles, some tense hallway conversations between partners at top-tier firms. Then, late yesterday, the whispers turned into a full-blown legal confrontation that now has federal judges raising eyebrows and blocking executive power. The Trump administration, already tangled in a web of litigation over its aggressive reshaping of federal programs, is now facing serious pushback from the judiciary after issuing a controversial executive order aimed at punishing a prominent law firm. That firm, still unnamed in official court records at the time of publication, was behind a successful lawsuit against Fox News several years ago, a case that challenged the network's role in spreading false claims of election fraud. This time, it's not just about political ideology or partisan spin. According to a federal judge who issued a restraining order just hours after the executive action was signed, it's about power and whether that power is being abused. The executive order in question sought to strip the law firm of its current and future government contracts. The reasoning, according to sources inside the Department of Justice, was based on a vague claim that the firm had acted in ways hostile to federal interests. But critics say the real reason was retaliation for taking on and defeating one of the administration's most reliable media allies in court. The judge didn't mince words. In his ruling, he called the order a shocking abuse of power. Legal scholars say that's not hyperbole. There is no clear precedent for punishing a law firm because it won a case, said one senior attorney familiar with the situation. That's not how a democracy functions. If the government starts blacklisting firms simply because they were on the wrong side of a political dispute, we're dealing with something far more dangerous than policy disagreements. We're dealing with an erosion of constitutional norms. The constitutional issue at hand is the First Amendment, specifically whether a law firm's advocacy in court counts as protected speech. The answer, according to multiple legal experts, is yes. Absolutely, yes. If you're arguing to a judge, presenting a case, engaging in litigation, that is a form of speech, said a constitutional attorney with ties to the case. And not just any speech. It's in the highest tier of First Amendment protection. That's core democratic activity. So when the government targets a law firm for that speech, it walks a dangerous line. It raises the question of whether a president can use executive authority to punish those who legally oppose him. The administration's defenders argue that this isn't about free speech, it's about business. We can choose who we do business with, one White House official said, speaking on background. If a firm is acting in a way that we think harms the government's interests, we have every right to reconsider our contracts with them. But critics say that argument doesn't hold water. It's one thing to end a contract for performance issues, said a former DOJ official. It's another thing entirely to end it because of what a firm said or argued in a courtroom. That distinction may end up being key in the courtroom battles ahead. There's also a deeper concern among legal professionals, a cultural one. Lawyers, even those working for high-powered firms with billion-dollar portfolios, are now questioning whether their advocacy could put a target on their backs. This hits close to home, said one attorney who asked not to be named due to fear of retaliation. If we're now being punished for doing our jobs, for representing clients and making legal arguments, then no one is safe. Today, it's this firm. Tomorrow, it could be any of us. The situation has also sparked rare unity in the legal community, which is often fractured along ideological lines. Several legal associations have already begun drafting amicus briefs in support of the blocked firm. A joint statement from the National Association of Trial Lawyers and the Federalist Legal Alliance, two groups rarely on the same page, condemned the executive order as an authoritarian threat to the foundation of the legal profession. What makes this all more volatile is the memory of recent history. The lawsuit that sparked this retaliation wasn't just any case. It was one of the most high-profile legal rebukes of the post-2020 election narrative. The firm successfully sued Fox News, forcing them to settle over claims they aired that falsely suggested the 2020 election had been rigged. The legal victory was seen as a turning point in the accountability of media outlets. But now, that win has put the firm in the crosshairs of a president determined to rewrite the rules. Sources close to the case say the firm has no intention of backing down. "We believe in the rule of law," said a spokesperson, "and will fight this attempt to undermine it." Legal experts predict this won't be the last legal clash of its kind. This is part of a broader pattern, said a law professor who's been tracking recent executive orders. There's a consistent theme: punishing dissent, centralizing authority, and undermining institutions that are meant to be independent. The courts, the media, the legal bar, they've all come under attack. And now, once again, the judiciary is being asked to draw the line. The federal judge's restraining order is just a temporary measure. More hearings are scheduled for later this week. But for now, the message from the bench is clear. Even in a time of political warfare, there are rules, and even presidents are expected to follow them. This story is still developing, but one thing is certain: the fight over legal independence is far from over, and the outcome could redefine the boundaries between the White House and the courtroom for years to come. As courtrooms fill and legal associations mobilize, the confrontation between President Trump's administration and the American legal system deepens. The executive order targeting a prominent law firm has become more than a legal scuffle. It's now a litmus test for how far the federal government can go in punishing dissent under the guise of bureaucratic discretion. Inside the legal world, alarm is turning into action. Within 48 hours of the court's restraining order, over a dozen law firms signed a joint declaration condemning the executive order and pledging legal and financial support to their embattled peers. This isn't just about principle, it's about survival. Firms that typically compete with each other for billion-dollar contracts are now banding together, recognizing that a precedent set against one of them could soon be used against all. We're not talking about a tax dispute or a contract termination over missed deadlines, said a partner at one of the nation's top 10 firms. We're talking about an attempt to use the power of the presidency to retaliate against a law firm for winning a case, for doing its job. At the heart of the uproar is the First Amendment. Again, the administration continues to argue that it's merely exercising discretion in choosing its business partners. But many constitutional experts see that explanation as flimsy cover for what amounts to ideological retaliation. Sure, the government can cancel contracts, said Professor Laura Kim, a constitutional law scholar at Columbia University, but not for reasons that infringe on protected speech. If the underlying motive is punishment for legal arguments made in court, especially arguments that were accepted by a judge, then it's unconstitutional. Full stop. And this isn't happening in isolation. Over the past several months, Trump has issued a string of executive actions aimed at weakening institutions that have pushed back against his policies. A grant freeze on universities that hosted panels critical of government immigration policy. A directive reviewing federal funding for news outlets accused of spreading disinformation, a term critics say is now being applied to factual reporting that challenges the administration. And now, law firms. The strategy, according to former officials and political analysts, appears to be an attempt to intimidate key sectors of civil society: the media, academia, and the legal profession. In all three areas, speech is not only protected, it's foundational. If you can pressure universities to avoid criticism, if you can freeze out media companies that report the facts, and if you can punish law firms that win cases against you, then what's left? Said one retired federal judge. These are the safeguards of democracy. But the backlash is growing. Protests are now being planned in multiple cities under the banner, "Defend the Courts." Legal students at Georgetown and NYU organized sit-ins this week, calling the executive order an attack on justice. Even some of Trump's political allies have expressed concern. Senator Rick Meadows, a longtime supporter of the president, said during a radio interview, "Look, I support strong leadership, but not at the expense of the Constitution. We've got to make sure we're not setting a precedent that will come back to haunt us." Behind the scenes, the Department of Justice is reportedly divided. Some career officials have expressed unease over the implications of enforcing the executive order. One senior DOJ lawyer, speaking anonymously, said, "There's a reason this went straight to a restraining order. The legal reasoning behind this move is so thin, it's almost translucent." Public opinion remains mixed, however. Among Trump's base, the move is being cast as a strike against elitist institutions and activist lawfare. Right-wing media commentators have praised the executive order as a bold stance against what they describe as a politicized legal establishment. But outside of that circle, many Americans are watching with growing concern. If this happened in another country, we'd call it what it is: government overreach, said a former state Supreme Court justice. We'd say the administration is trying to silence legal dissent. But because it's happening here, people hesitate. That hesitation is dangerous. At the core of the legal argument is one question: is the litigation process protected speech? The answer from most legal scholars is yes. When attorneys argue in court, file motions, or represent clients, even controversial ones, they are exercising core First Amendment rights. This has been affirmed in multiple Supreme Court rulings over the decades. Undo that principle now would not only reshape the legal profession, it could open the door to political persecution in ways not seen in modern American history. And that's the nightmare scenario that many fear. If the government can retaliate against lawyers for who they represent or what cases they argue, then no one is safe, said retired appellate judge Vanessa Curran. Next, it's criminal defense attorneys, then immigration lawyers, then public defenders. It becomes a tool for suppressing the rule of law. In the meantime, the affected law firm is preparing to fight back. Sources close to the team say they plan to challenge the order on constitutional grounds, potentially taking the case to the Supreme Court if necessary. Their argument will be built on a long-standing doctrine that government retaliation against protected speech violates the Constitution. Their first hurdle will be to convert the temporary restraining order into a permanent injunction. Legal experts say that's likely, given how strongly the initial ruling was worded. But the administration has shown no signs of backing down. In fact, according to internal memos obtained by investigative reporters, additional executive actions are being drafted that could further escalate tensions. One draft proposal allegedly seeks to create a federal contractor loyalty review, which would assess a firm's alignment with what the administration calls American governance principles. Critics say the language is intentionally vague and potentially chilling. This kind of policy signals to everyone, lawyers, journalists, teachers, that there's a cost to criticism, said Professor Kim. It's not a law banning speech. It's something more insidious. It's a climate of fear. And that's the bigger story. Not just the legal battle over one law firm's government contracts, but a broader, more urgent question. What kind of country are we becoming if protected speech can now carry a price? As the judiciary moves to weigh in again, and as Congress begins to stir with bipartisan concerns, one thing is becoming clear. This isn't a typical legal dispute. It's a collision of law, power, and principle, and the whole nation is watching. That concludes our in-depth look at how the Trump administration's recent actions are colliding with long-standing legal norms, and why this moment could redefine the boundaries of executive power and free speech in America. What do you think? Is this a necessary correction to a biased legal system, or a dangerous overreach that threatens the foundation of democracy? Drop your thoughts in the comments below. We want to hear from you.